is Vijay from CLAT 100, and here in this session we are going to discuss all 12 legal reasoning questions that were asked in shift 1 of SLAT 2021. And I have a suggestion for you. We have given the PDF of all these 12 questions in the description of this video. So why don't you go to the description, solve these 12 questions on your own, and then watch this video. Here is your first question. Refusal to issue a writ of habeas corpus under Article 226 does not bar the remedy for a similar writ under Article 32 of the Indian Constitution. And the reason is habeas corpus writ is an exception to the rule of res judicata. What exactly is res judicata? Matter once adjudicated cannot be re-adjudicated, alright? But habeas corpus is an exception to this, is actually an exception to this, alright? So here your answer is both A and R are true, and R is the correct explanation of A. Here the principle is necessity is a good justification for the loss caused to the plaintiff. The facts are like this. A fire originates in A's house through some unknown defect in the electrical installation. In extinguishing the fire, B's adjoining property is damaged by water. B brings an action against A, claiming damages for the damage caused to his property. Now you need to decide. Alright, first of all, what do you think? Should B succeed? What's your opinion? Should or shouldn't? Alright, now here, of course, the obvious answer should be that B should not, B cannot. Alright, once you have decided this, then you do not need to read all 4 options. Okay, like options B and C, start with B can succeed, B can succeed. Why should I be reading these 2 options? Because if I read these options, I'm wasting my time because time is limited. You have to do the entire paper in 60 minutes. Alright, so first of all, B of course cannot succeed. Read option A. B cannot succeed since water is a natural thing and not hazardous. Alright, this is ridiculous. So very smart test takers will just read option A, B and C. They will stop at after reading B can succeed and B can succeed. Then why do I need to read D? D has to be the correct answer, isn't that? B cannot succeed since A was acting under sheer necessity. Now, acceptance must be in the same sense of the proposal and the manner so provided. J proposed to Y to sell a table for 600 rupees. Y expressed his desire to buy the said chair for 500 rupees. So is he accepting the proposal in the manner so provided? Of course not. So first of all, decide. Is it acceptance? No, it's not an acceptance. So Y has accepted the proposal. Just stop there. Y has accepted, stop there. It is not clear whether Y accepted the proposal or not. Okay. Of course, the answer is simple. Y has not accepted the proposal of J. And I do not have to read many options. The moment I spot that, I should stop. A crime consists of 2 essential ingredients, mens rea and actus reus. Of course, I'm sure you know. Riddhi, who has been absent from school for a week, goes to the library and takes away Sheena's notebook to make notes. She leaves a letter at the table for Sheena, mentioning that she is taking her notebook and will return it tomorrow. But the letter was not read by Sheena. Will Riddhi be liable for theft? Actus reus was there. Was there any mens rea? Was there any mental element? Did she intend to steal it? No, she didn't. Will Riddhi be liable for theft? You know the answer has to start with no. So do not even read options B and C because these 2 options start with yes. Okay. Now read option A. No, she did not take it for keeping it permanently. Okay. You think this can be the answer? Of course not. So straight away, even without reading option D, you know that D is the answer because you have already eliminated options A, B and C. Of course, even though she took it, but there was no mala fide intention or mens rea on her part. Of course, but you never needed to read this option in order to get it. Manu, An APSRTC bus driver finds himself in a situation where he has no other option but to run over a cafe full of people. Oh, sad. In order to avoid, he takes a turn and runs over a biker. Sad. The biker dies on the spot. Is the bus driver liable? First of all, what do you think, commonsensically? Is the bus driver liable? He tried to save a good number of people who were there in the cafe. Alright, and he certainly did not intend to kill the biker. The biker got killed is a different thing. So, do not even read those options that start with the bus driver is liable. So, options B and C you do not have to read. The bus driver is not liable, option A, because killing a single biker is better than killing more people inside the cafe. Okay. D. The bus driver is not liable because through his action, he had no mens rea to kill the biker. Rather, it was an unavoidable situation. Another hint, options A and D are close, but option D explains it better. What do you think? So that's the answer. Mr. Sam had a black Labrador, Justice, okay, 5 years of age. One fine day, he left his dog unattended. Mind you, very important point, he left his dog unattended. Meanwhile, Bruno, who was Mr. Sam's neighbor, started throwing stones at Justice. Okay, Justice got furious and started running. As a result, a woman and a child were in danger. A policeman saw the situation and came to save the woman and child. But meanwhile, he got injured. Okay, sad. The policeman demanded damages from Mr. Sam. Now here, whatever answer we give to you, take that with a pinch of salt, because no legal principle was given here in this question, and there can be many different interpretations here. We shall try our best to come with the most acceptable option. Okay, policeman can recover the damages from Mr. Sam as he was trying to protect the woman and child. Alright, damages from Mr. Sam as he was trying to protect the woman and child. Does it sound convincing? Okay, so leave it. Policeman can recover the damages from Bruno only. But what about Mr. Sam? He certainly had left the dog unattended, right? And that too a Labrador. Alright, policeman cannot recover the damage as it was voluntae non fit injuria. Now that is where I get stuck with some questions of SLAT. If they haven't given any legal principle, alright, should I give any importance to option C? And is that actually important here? Option D says policeman can recover the damages from Mr. Sam as he left the dog unattended. So Mr. Sam should pay for the damages. Of these four options without any legal principle, option D appears to be the most convincing option to us. Now here the principle is child labor is strictly prohibited and punished in places of hazardous employment. Look at the facts now. Raju, a 12-year-old boy, was the only child of his parents. Okay, they both were daily wage earners. One day, they both fell ill and there was nothing to eat at their home. Alright, Raju asked the nearby factory owner Ramesh Bhai, having a firecracker manufacturing unit, to provide work at his factory. Raju started working at his factory. Alright, okay. Now, look at the options. The factory manufacturing unit was not so hazardous, so Ramesh Bhai will not be prosecuted. Firecracker manufacturing unit is hazardous. Alright, so option A is straight away ruled out. The child has to work out of necessity. Is there any necessity clause there in the principle? No, so why do I have to even read it completely? Ramesh Bhai did something good apparently, but so what? You cannot allow your emotions to get better of your sense of legal reasoning. The nearby factory owner Ramesh Bhai will be prosecuted for committing offense of child labor. Of course, yes. Of course, yes. Now look at option D. Ramesh Bhai cannot be prosecuted as the offer to work was given by Raju only. Is there any such mention in the principle? Of course not. Moreover, even before you start reading the options, ask this question to yourself. Should Ramesh Bhai be prosecuted? Not as per your emotions, but as per the principle given here. And the principle will make you believe that yes, he should be prosecuted. And now there is only one option that asks for prosecution for Ramesh Bhai, and that is option C. So that should be your answer. An agreement is void and unenforceable if consideration and objects are unlawful. A police officer entered into an agreement with B to get supply of 15 Alexander Kalashnikov rifles. Oh God, you think that the object is lawful or is it unlawful? If you think it's unlawful, it's over here. A promised to pay a sum of 2 lakh rupees and B supplied the guns, but A refused to pay the sum promised. B can move to the civil court. B can file writ petition. Okay, these two options should not even be read. B cannot move to any court for enforcement of contract. Of course, yes, B cannot move to district court, but only to High Court or Supreme Court. Okay, so of course, B, C and D can be ruled out. The answer has to be option A. Okay, all right. A, while walking on a street, thrust his hand in B's pocket for stealing valuables, but the pocket was empty. A is guilty of theft, not guilty of theft, guilty of attempt to commit theft, not guilty of any offense. Alright, so here also, no legal principle is given, so you have to use your common sense and a bit of legal knowledge also. So, which option should we rule out straight away? Options A and D for sure. Not guilty of any offense. If there is no offense in it and everyone on road starts putting his hand or her hand in someone else's pocket, what would happen? Guilty of theft. Is there any theft here? No. So A and D are straight away ruled out. What about option C? Guilty of attempt to commit theft. But here we do not know about the phrase attempt to commit theft. So the safest option is not guilty of theft. And this is my request to SLAT people. Please give some legal principle to such questions. So the best answer in our opinion is option B. Now here, the principle reads, necessity knows no law and any person in danger. Mind you, any person in danger may do all that is necessary in order to avert the same till he can take recourse to public authorities. So there are two parts to it. First of all, the person should be in danger. Any person in danger may do all that is necessary in order to avert the same till he can take recourse to public authorities. But first of all, the circumstances should be so. Alright, let's read the facts. Manu, a law-abiding citizen of the country, wanted to weed out corruption from the Indian society. Alright, is a very fair want. One day, he confronted an official who took bribe. Manu decided to teach him a lesson and punched him on his face. Okay, if Manu had to teach him a lesson, he should have complained against this person, should have lodged a case. Alright, was he in any kind of danger? Were the circumstances so that he needed to punch him in his face? Was it like that? No, of course not. So isn't it a very clear case? Alright, let's read the options. Cannot plead defense of necessity as there was time to take recourse to public authorities. But taking time to recourse to public authority is secondary. Primarily, he should be in danger. Circumstances should be so. Alright, but this is a good choice, it's not a bad choice. Okay, can plead defense of necessity. First of all, we are sure by this time that he cannot plead the defense of necessity. So I do not think that I need to read it completely. Cannot plead defense of necessity as there was no necessity to act in a manner he acted in. Yes, there was no danger. There was absolutely no necessity to do it. So this seems to be more convincing than this, isn't that? Let's read the fourth option as well. Can plead defense of necessity. Cannot plead defense of necessity. So here, of course, the answer is option C. And mind you, first of all, we had to answer whether he can plead defense of necessity or not. Commonsensically, we could make it out that no, he could not plead the defense of necessity. So straight away options D and B were out of contention. Then we were left with A and C. A is a close choice, but if you look at it carefully, C is a better answer. Alright, Which one of the following is the correct sequence with reference to a valid contract? Come on, here I do not think it's worth discussing. Of course, offer, acceptance, consideration and agreement. Option A. Mistake of fact is excusable, but mistake of law is not. Suraj was standing in his balcony at night and saw someone climbing on their wall. Oh, must have got scared. He got afraid and thinking him to be a thief, hit him with a stick and he fell. Alright. Later, it was revealed that it was his neighbor who was just trying to pick clothes which were taken by wind on Suraj's wall. You never do it. Wait for it to be the morning. Okay? Decide the liability of Suraj. Okay, what do you think? It was a mistake of law or mistake of fact? Of course, mistake of fact. Did Suraj intend to hit his neighbor? Did he? No, he didn't, of course. Now, Suraj is liable for negligence? Of course not. Suraj is not liable as he mistook his neighbor to be a thief. True. So, there's your answer. Suraj is not liable as he just hit his neighbor with a stick and the neighbor fell down on his own. Just laugh at this option. It's a comic relief. Alright. Suraj is liable for grievous hurt as he hit an innocent man. I mean, what to say? Of course, so you know your answer. That is B. And please be on our Telegram group because we have put lots of valuable content for you there, which help you prepare for different competitive examinations on law. And if you like this effort, please give us a thumbs up, share it with as many people as possible, subscribe to CLAT 100 if not done already, and press the bell icon hard so we keep you updated on what all we are doing on the channel. All the best.